This lesson will help you understand the Fourth Amendment, how to apply it and the rule of searching, seizing property or person while in the performance of your duties.
As a military or civilian police officer, you will have to apply the Fourth Amendment. With every case you investigate, every traffic stop you perform, and every suspect you will search during investigation, you need to understand how the Fourth Amendment works and how to apply it while in the performance of your duties. By not understanding the Fourth Amendment, you will most likely violate someone's civil rights, which could lead you up to court-martial, termination, or better yet, prison.
The right of the people was established because of English rule in 1776, where many Americans were illegally searched by the king's soldiers, thus preventing any person or property from being seized by the government without evidence, warrant and probable cause to do so. Fourth Amendment idea that citizens should be protected from unreasonable searches and seizures goes back far into English history. In 1604, in the famous Smains case, the judge, Sir Edward Coke, first identified this right. He ruled that the house of everyone is to him as his castle and fortress, as well for his defense against injury and violence as for his repose. In this case, it was determined that subjects of the kingdom had the right to be protected from searches and seizures that were unlawfully conducted, even if they were conducted by the king's representatives. The case also recognized that lawfully conducted searches and seizures were acceptable. This case established a precedent that has remained a part of English law ever since. The most famous English case dealing with the right to freedom from illegal search and seizure is called Entick v. Carrington, 1765. In this case, royal representatives had broken into the private home of John Entick in search of material that was critical of the king and his policies. In the process, they broke into locked boxes and desks and confiscated many papers, charts, pamphlets, etc. The officers were acting on the orders of Lord Halifax. During the trial, Entick charged that the entire search and seizure had been unlawfully conducted, and the court agreed. The court said that Lord Halifax had no standing to issue the order to search the premises, that probable cause that a crime had been committed had not been demonstrated, and that the warrant allowed a general confiscation of anything the officers found, not specifying exactly what they were to look for or could seize. In addition, there were no records kept of what the officers seized. Charles Pratt, Lord Camden. This ruling essentially declared that the government was not allowed to do anything that was not specified by law. It required the search and seizure be carried out according to the law. It also established that the right to be able to protect one's private property was an important right to be safeguarded by the government. In his ruling, Lord Camden, the Chief Justice, made this famous statement: "The great end, for which men entered into society, was to secure their property. That right is preserved sacred and incommunicable in all instances, where it has not been taken away or abridged by some public law for the good of the whole." The cases where this right of property is set aside by private law are various. Distresses, executions, forfeitures, taxes, etc. are all of this description. Wherein every man by common consent gives up that right, for the sake of justice and the general good. By the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set his foot upon my ground without my license, but he is liable to an action, though the damage be nothing. Which is proved by every declaration in trespass, where the defendant is called upon to answer for bruising the grass and even treading upon the soil. If he admits the fact, he is bound to show by way of justification that some positive law has empowered or excused him. The justification is submitted to the judges, who are to look into the books. And if such a justification can be maintained by the text of the statute law, or by the principles of common law. If no excuse can be found or produced, the silence of the books is an authority against the defendant, and the plaintiff must have judgment. The Fourth Amendment of the U.S. Constitution provides, "The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized." You have 4 levels of suspicions. Let's go through them now. 1. No suspicion. You are speaking with a driver who is attempting to access your gate. 2. Mere suspicion. The driver's behavior is strange. 3. Reasonable suspicion. You see what appears to be an open container of alcohol inside the vehicle in plain view. 4. Probable cause. You smell the odor of alcohol emitting from inside the vehicle. Now let's recap. The driver is no longer free to leave. Now you are performing a Terry stop, because you are investigating the incident. You can now remove the driver from the vehicle, his property, while you investigate further. The open container of alcohol can be seized by you. The government official, since the container is in plain view. Since you have probable cause the driver may be intoxicated, you may seize the driver if he fails your SFSTs during the investigation, and detain the driver for the violation of driving while under the influence of alcohol, also seizing his vehicle in the process. Reasonable suspicion is a legal standard of proof in United States law that is less than probable cause, the legal standard for arrests and warrants, but more than an inchoate and unparticularized suspicion or hunch. 1. It must be based on specific and articulable facts, taken together with rational inferences from those facts. 2. If police additionally have reasonable suspicion that a person so detained is armed and dangerous, they may frisk the person for weapons, but not for contraband like drugs. Reasonable suspicion is evaluated using the reasonable person, or reasonable officer standard. 3. In which said person in the same circumstances could reasonably suspect a person has been, is, or is about to be engaged in criminal activity. It depends upon the totality of circumstances, and can result from a combination of particular facts, even if each is individually innocuous. Probable cause. Probable cause, known as PC, is a level of reasonable belief, based on facts that can be articulated, that is required to sue a person in civil court or to arrest and prosecute a person in criminal court. Before a person can be sued or arrested and prosecuted, the police and prosecutor must possess enough facts that would lead a reasonable person believe that the claim or charge is true. In Terry v. Ohio, the U.S. Supreme Court ruled that a person can be stopped and briefly detained by a police officer, based on a reasonable suspicion of involvement in a punishable crime. If the officer has reasonable suspicion, the officer may perform a search of the person's outer garments for weapons. Such a detention does not violate the Fourth Amendment prohibition on unreasonable searches and seizure, though it must be brief. Reasonable suspicion does not provide grounds for arrest. However, an arrest can be made if facts discovered during the detention provide probable cause that the suspect has committed a crime. A Terry stop is a stop of a person by law enforcement officers based upon reasonable suspicion that a person may have been engaged in criminal activity, whereas an arrest requires probable cause that a suspect committed a criminal offense. The name comes from the standards established in a 1968 case, Terry v. Ohio. Let's take a look at some probable cause. 1. Plain view. 2. Eyewitness testimony. 3. Suspect confession. 4. Physical evidence. Plain view doctrine. The rule that a law enforcement officer may make a search and seizure without obtaining a search warrant if evidence of criminal activity or the product of a crime can be seen without entry or search. Example: a policeman stops a motorist for a minor traffic violation and can see in the car a pistol or a marijuana plant on the back seat, giving him reasonable cause to enter the vehicle to make a search. Eyewitness testimony is the account a bystander gives in the courtroom, describing what that person observed that occurred during the specific incident under investigation. Ideally, this recollection of events is detailed, however this is not always the case. This recollection is used as evidence to show what happened from a witness point of view. Suspect confession can be written or verbal. This is when the suspect admits to the crime you are investigating. Physical evidence is evidence collected while you are on scene that can be linked to the suspect. This evidence can be DNA, fibers, fingerprints, video, and photographs.
Okay, let's review. You have just stopped a vehicle for running a stop sign. You observed in the back seat of the vehicle, in plain view, burglary tools, black ski mask, a lot of driver licenses and a bag of jewelry. Do you have reasonable suspicion the driver has committed and/or is about to commit a robbery? Can you perform a Terry stop on the driver while you investigate? Can you Terry frisk the driver while you are investigating the incident for officer safety? Do you have enough probable cause the driver may have committed a robbery? Yes, you may detain the driver for being in possession of burglary tools and seize the jewelry while your investigation. You have been just dispatched to Laurel Bay Boulevard for an Amber Alert. Red pickup truck last seen in the area of Laurel Bay Boulevard with a young white female juvenile. Can you stop any vehicle matching the description of your bolo? Can you stop all of these vehicles while you look for the missing girl? Yes, you have probable cause to search any vehicle matching the bolo description. Be on the lookout for white male, 6'1", 280 pounds, bald head, tattoo on chest which says "True came in", wanted for murder, Chester County NCIC warrant verified. While at a resident, you see a person without a shirt matching your bolo description. Can you briefly detain the person until you verified who he is? Yes, you have reasonable suspicion that the person you are speaking with may be your suspect. This concludes your Fourth Amendment training. Apply the elements you have just reviewed.